Okay, I think we might have everyone. So thank you everyone for joining us today on this rather sunny, spectacular day. I'd like to welcome you to this seminar on 8 key cases that you should be aware of in my matrimonial finance cases. This seminar will be given by the head of Goldsmith Chambers family team, Melissa Millin, and specialist finance practitioner, Victoria Wilson. There are a few housekeeping issues. If you're worried at all, you are on mute as you enter, so please don't panic that you can't find a mute button. We can't hear you. This seminar will be recorded, and the recording together with the slides and a note, a detailed handout will be found on our website, I think from tomorrow. So if you have a look tomorrow, you'll be able to find that. There is a box that should be on your screen marked Q&A. If you put any questions you have in that box, I'll be able to read those, and hopefully Vicky and Melissa will have some time at the close of the seminar to answer any questions you have. So do put them in there, and I'll read through those as we go on. There is also a comments box. You can use either, but the Q&A box is a little easier for me to read. So if you could use that one, I'd be very grateful. That is all from me. So I'd now like to hand over to Vicky to start us off.
Thanks very much indeed, Jo. Let's get the first slide up, please. Right, now before you retire to your desert island, what I'm going to suggest is that you familiarise yourself with Section 25 of the Matrimonial Causes Act 1973. The reason I suggest you have a look at this is because it contains the matters to which the court is to have regard in deciding how to exercise its powers in a financial remedy case. So in essence, it's the backdrop of every financial remedy case that you do. And subsections 1 and 2 are particularly important, and we'll briefly go on to look at them now. If we can go please to the next slide, Jo. The first, subsection 1, tells us that first consideration is given to the welfare of any child of the family who's not attained the age of 18. That's my emphasis there. So in any financial remedy case, your starting point is looking at whether or not the child has attained the age of 18, and that's a first consideration there. If we look now at subsection 2, that's what we call the Section 25 factors. Again, I'm not going to go into them in great detail, but I've highlighted in bold the aspects that are of particular importance when you go back and look at it after this seminar. We've got income, earning capacity, property, and other financial resources. We've got financial needs, obligations, and responsibilities. If we go over, we've got standard of living, age of each party and the duration of the marriage, any physical or mental disability, the contributions of the parties. G is conduct. It's quite extreme conduct, so you've got to use that power sparingly. And H is one that we don't come across so much, but we include that for the sake of completeness. Any benefits you lose the chance of acquiring, but I'd suggest probably A to F are the most important ones. Let's turn now to our first key case, the very important one. This is White and White. This is the case that every financial remedy practitioner should know. The reason why is it's the first occasion when the House of Lords considered the principles judges should apply when hearing applications under the Matrimonial Causes Act. So I suggest it's probably one of the most important cases. If we look at the background briefly, this was a case where the parties had assets of 4.6 million. So it was clearly a big money case. These assets exceeded the parties' financial needs. It was a long marriage. The parties had been married for over 30 years. This wasn't a case where children were of relevance because their children were adults and independent. Both parties came from farming families, and throughout the marriage, they carried on a successful dairy farming business in partnership. I'll now turn to the court proceedings. Now, at first instance, it was before Mr. Justice Holman. He decided to award the wife slightly over 1/5 of the parties' total assets. And what's important about his first instance decision is that he based the award on her reasonable requirements for housing, stabling for her horses, and based on her reasonable income requirements. She wasn't happy. She appealed to the Court of Appeal and she succeeded. And so her share of the total assets went up from 1/5 to about 2/5. And at Court of Appeal level, the farming partnership was regarded as a dominant feature in the case. Husband, needless to say, wasn't happy because he preferred the first instance decision. He appealed to the House of Lords and sought restoration of Holman J's order. And the wife cross-appealed because she wanted an equal share of all the assets. And the House of Lords ended up dismissing both appeals. If we move on, we're next looking at Lord Nichols's judgment. He gave the leading judgment in white and white. It's quite a detailed judgment, so I'm going to pick out some of the most important aspects of it over the next couple of slides. He reminds us that the objective of Section 25 of the Matrimonial Causes Act must be to achieve a fair outcome. And he reminds us that first consideration must be given to the welfare of the children. He then goes on to talk about fairness. And he says, and this is quite crucial, that there must be no bias in favour of the money earner against the person who's the homemaker and the child carer. And then we have this phrase which comes up again and again in financial remedy cases, that a judge would be well advised to check their views against the yardstick of equality of division. So that phrase you will hear time and time again in money cases. And he says, as a general guide, equality should be departed from if and only to the extent that there's a good reason for doing so. But what I must make clear to you is that that does not mean there's a presumption of equal division. Lord Nichols particularly addressed that in his judgment, and he spelt out that a presumption would be an impermissible judicial gloss, he called it, on the statutory provision. And so please bear in mind that we're not talking about presumption of equality. Yardstick of equality is the phrase to remember. Now, continuing with his key points from the judgment, he explains to us that Section 25.2, which is the Section 25 factors we saw previously, doesn't rank the matters listed in any kind of hierarchy. So in this case, financial needs, he says, is only one of the several factors. The court must also look at available resources and contributions. He then goes on to consider the first instance judgment of Holman J and says that basically Holman J was wrong because he misdirected himself about reasonable requirements. And so Lord Nichols says that the Court of Appeal was entitled to exercise its powers afresh. And in essence, the House of Lords decision is the Court of Appeal decided well within its ambit of discretion, and as such, the Court of Appeal decision was upheld. Now we're going to move on next to key case 2. This is called the self-help one. Now I'm going to give you the spoiler, you see, that don't get too attached to this case of Hildebrand. I'll tell you a bit about it and it will become apparent why you shouldn't get too attached to it. So let's look at its relevance now. This is a case where the husband went snooping around and copied documents contained in the wife's personal box file. For the next 8 years or so in money cases, this case came to be synonymous with self-help, as you can see it's termed here. And the accepted practice was clients were encouraged to access documents belonging to the other spouse, whether confidential or not, provided that force was not used. Once they'd got hold of such documents, they could retain and use copies, not the originals, they had to give them back to the other side. So this whole culture of self-help evolved in the family courts for a good 8 years. However, if we move on next to key case 3, we then come on to a different view and a game changer with the case of Immerman and Cengiz and others, which was a Court of Appeal decision from 2010. And this completely changed the landscape following Hildebrand. Now, just to explain the background in this case, it involved property tycoons. The husband in this matter shared an office and computer facilities with the wife's brothers. Within that office, he had his own password protected computer. The wife petitions for divorce, and out of misguided loyalty, one of her brothers accesses the server and makes electronic copies of emails and other documents. And we're talking vast amounts of material, at least 250,000 pages, probably closer to 2.5 million. And the other brother, wife's other brother, also was aware of what was going on. Now, their explanation for doing so was that they were worried about their sister's interests. Apparently, the husband said that the Cengiz family, and particularly the wife, would never be able to find any money because it was well hidden. So that was their justification for basically obtaining all that documentation. If we move on now to the court proceedings, they were complex, but in essence, there were parallel proceedings in the Queen's Bench Division and in the Family Division regarding the use of those documents. And this resulted in conflicting orders. Mr. Justice Millin decided at first instance that the documents should be handed back to husband, and he could remove anything privileged, but then husband would have to return the remainder of the files to wife and she could use them in matrimonial proceedings. Husband appeals against that decision, wife cross appeals. She wanted more control over the process by which husband could assert privilege, and there was another issue regarding the disposal of certain memory sticks. Now, if we can turn now to the judgment, basically the judgment upheld the order made in the Queen's Bench Division. So this is the Court of Appeal saying, we agree with the QBD, wife must hand over the documents and copies to husband's solicitors and not to part with those documents unless wife's solicitors agree in writing or the court permits them to do so. And quite crucially, wife was restrained from using any of the information obtained through reading those documents. And this led some to say, well, this is a bit of a cheat's charter, really. She can't use any of this stuff that he may be hiding. So what to do? If we go on to the next slide now, what's the position now? The judgment makes this very clear. It says there's no basis for any special self-help rules in family proceedings. So that's explicitly going against what came to be the Hildebrand culture preceding this. There are no rules which dispense with the requirement that a spouse obeys the law. The judgment goes into the issue of confidentiality and communications that are concerned with an individual's private life are confidential. And the judgment makes clear that it's unacceptable to sanction a party taking the law into their own hands to get a premature advantage. So quite understandably, you'd want to know, well, what are we supposed to do with that? The court deals with this in the judgment and explains that the remedy is for the court to utilise its power to grant search and seize, freezing, preservation and other orders to ensure that assets are not wrongly concealed or dissipated and that evidence is not destroyed or concealed. And the judgment sets out that if there is a serious substantial concern that a party is concealing or dissipating assets or trying to destroy documents, then it's very likely indeed that a peremptory order to protect the other party's rights would often be justified. Now, what I would probably suggest, because this does come up a fair bit in practice, is if you have a client who turns up and gives you documents which they're not supposed to have, my suggestion is that you return them unread to the other side's solicitor. Ask that solicitor to keep them on file, but also suggest they consider whether any or all of them be disclosed. So that's the clear protocol and what we're expected to do nowadays. So don't take the Hildebrand route and have that case in mind, because it's a very common issue in financial remedy practice and you're bound to encounter it at some point. If we now turn to my fourth case, this is the unspellable one. This is Zidias, and the message from Zidias is an agreement may be binding if the broad heads are clear. Now, if we look at what happened briefly in Zidias, if we go to the next slide, please, Joe, this is a case where there were lengthy negotiations going back and forth between counsel regarding the terms of a consent order. Eventually, they get to the fourth draft of the consent order, and it appears to be agreed, happy days. So they notify the court the case is settled, and the final hearing gets vacated. However, it takes a turn for the worse, because the husband then tries through his representatives to vary the timetable. He was ordered to pay a lump sum, and he tries to vary the dates for that lump sum. This doesn't go down at all well with wife or her solicitors, and they say no. At which point the husband, through his solicitor, says, well, I've withdrawn all instructions now. I've withdrawn all offers. We're going to fight it to the end. That's it. All bets are off the table. So it goes to court. There's a final hearing. As a preliminary issue, the wife argues that agreement has been reached, and the district judge agrees, and husband appeals. Now, the result of that case was that his appeal was dismissed, And this is the key bit of it, the nub of it really. The judgment says that an agreement may be binding if its broad heads are clear. And it explains there are sound policy reasons for doing so, because the court doesn't want to clutter its time up with excessive litigation and full trial lists. So the key point is ordinarily heads of agreement signed by the parties or a clear exchange of solicitors' letters will establish the consensus. So that's a good case to have up your sleeve. If we ever get back to court when it's 5 o'clock, you finally reached agreement and you don't have time to type out an order there and then. If you do your bullet points, the main heads of agreement, and get them signed, this is the justification that should establish the consensus in most cases. Now, thank you very much indeed. I'm going to ask Melissa now to take over, and I'm happy to answer questions at the end.
Thank you, Vicky. My first case on the desert island is going to be Measure and Measure. That is where we get our measure orders from. That's one of the ways that we use to govern what will happen to the family home after a divorce. And in particular, what a measure order allows you to do is defer the sale of the family home until a specific period or perhaps a trigger event. Now, a measure order also has a childless cousin, that's a Martin order, and of course there's also a chargeback order. These are quite rare these days, but it allows the interest of children to be prioritised over that of any creditors. If we can move to the next slide, please, Jo. So the origin of the measure order flows from some provisions within the Matrimonial Causes Act, 1973, firstly section 24(1)b, that's an order for settlement of property. After that it's section 24(1)c, which is also a variation of the settlement that often applies depending on whether the property at the time the order is made is held in joint or on sole names. But generally, and on a practical level, these are distinctions that are assumed and not necessarily recorded within the order. Because effectively the parties are left with a trust for sale, there's scope in bringing forward that sale on the relevant dates, and this is done on an application. That can be either under section 24 capital A of the Matrimonial Causes Act or section 14 of Tolata. But the draft order should clarify the rationale behind the order, and that's the most important element. So what the order's meant to do is to allow the management or the deferral of the sale on these occasions. If we look at the trigger events, these can be detailed from a new relationship, an agreement to cohabit or remarry. It can be that children conclude their full-time education, or it can be on a set date agreed by the parties. But under the terms of the order, the property will remain in the joint names of the divorcing couple upon the trust for sale, and on the point of the trigger, then the proceeds are divided. So the features of a well-drafted measure order will contain some fairly obvious provisions, but it should make clear the ownership of the property in its proportion, who should occupy, who's going to be responsible for paying the mortgage, whether there's to be an indemnity, and who pays for the repairs. Looking forward through the list of events that can take place, what is clear that a poorly drafted measure order won't answer these questions. And in particular, you should look at the question of the variation of any terms, contingencies necessary, or the management and the restraint of borrowing that could, under some conditions, affect the interests of the other party. If we can move forward, please. Now, clearly, a measure order is not a perfect solution. It keeps the financial ties between the parties, and it's been criticised in the fact that it can have disadvantages for both the parties, the remaining party and the leaving party. There is enormous lack of control over the day-to-day arrangements, and there can be a feeling of great disturbance and disruption for the party when the final sale is enforced. And it leaves capital tied up for considerable periods of time. But the reality is, if we move forward to the next slide, sometimes it is the only option available, and it can't be overlooked when it's there to dig deep and reach to find what can meet the parties' needs. My next case is that of Duxbury and Duxbury. This is an amusing little case. It's a situation where the parties were in a 22-year marriage before it broke down. The parties enjoyed a very comfortable lifestyle before the divorce took place. And the husband chose to leave the family home. He was going to live with his mistress. The wife wanted to remain in the family home. She wanted to live with her, at the time, very much younger lover who was of insubstantial means and had no ability to keep her in the style she was to be accustomed. For the time, it was a fairly big money case, but the principle of Duxbury isn't about what happened in the case. That is not its magic. Where its magic begins is that there was a gentleman called Mr. Tim Lawrence. He worked for a firm at the time of Cooper's Lybrand, and he had developed a model of calculation that was used in the case to calculate the lump sum payment equivalent to a future maintenance payment. This is called an iterative calculation. And the reason that we use Duxbury is it's about the employment of the method. It is a calculation and not a guarantee. And what it does is it begins with an initial guess to generate a sequence of improving and approximate solutions, which should take you to a point where the class of problem is addressed, where the nth approximation is designed from the previous one. So the key aspect of what it can do is it can calculate a level of income stream necessary to convert into capital, or vice versa, it can convert capital into what is going to be generated from a necessary income stream. So as I said, it's very important to know what Duxbury is. It is a method of calculation. It targets a right to receive over a period of time. And the basic question the court should be asking itself is there enough in the sum if paid now or allocated now to give the other party what they would have in equivalent in the future? Perhaps that would be maintenance. So it looks at methods of capitalising payments without unfairness to either party. So if we look at where the Duxbury calculation might be useful, for very obvious areas, effecting a clean break in lieu of a periodical payment, it can be used to effect a clean break through variation. Again, that's another use of capitalisation. It can also be used as a reverse calculation to look at what the income would be generated from the retention of capital. And it can also be used as a reverse calculation to test if the resources there are sufficient to meet the future needs. And on that basis, it can calculate levels of capital that are needed to secure future periodic payments. If we move forward, please, Jo. It's a level of thinking that should be in the forefront of anybody's mind when looking at the case globally. But if you want to have a little tinker at trying to develop your own form of Duxbury assessment, it is possible using the Excel PV function and looking at the formula where effectively the present value rate is multiplied by the term and the payment. What I would also invite you to do, this is my desert island luxury, is become familiar with At a Glance. That's the essential tables for financial remedies. They're also very, very useful for calculating this through. And what needs to be known about making the calculations is that very simple adjustments at one end can have enormous consequences at the other. Now, that can be used in two different directions when you're looking at the viability of a matter, but it allows people to look globally and at long-term considerations. There are two anomalies that take place. If a party receives a capitalised payment and they either remarry or they die early, effectively the weight of that capitalised payment is greater and in their favour. Conversely, if somebody receives a capitalised payment of that sort and lives for a particularly long time, very often, ironically, that will put them in a different situation. but it puts the understanding of how money is going to be used at the forefront of people's thinking. Moving away from solutions of what we do with money on divorce, I'm going to go on to the next case, thank you, Joe, which is my desert island luxury item at a glance. The next case of Radmacher and Garantino. This is a Supreme Court decision, probably best known to help people understand the position of prenuptial contracts in a divorce scenario. And what needs to be very, very clear is the Supreme Court has been absolutely clear. This does not mean that there is a guarantee that prenuptials will be upheld, but there is a discretion to uphold a prenuptial contract. The parties in this instance, the husband was French, he was a successful banker, the wife was German. They had a daughter and they both entered into a prenuptial contract. This was a contract signed in Germany, the essence of which was neither of the parties would benefit from the other if and when the parties divorced. Well, they did. And whilst there was no agreement between the parties that could override Section 25 of the, Section 25, then what would happen was the court would be equipped with a very, very wide discretion as to how influences would be dealt with. The basic effect of a prenuptial contract is a court is willing to follow what has been previously agreed, providing certain circumstances are met. If we can move to the next slide, please. There needs to be absolute and full disclosure. There needs to be opportunity for independent legal advice. There needs to be consideration of the timing and overcoming of any question of coercion. So the message that the court is given is that it will uphold an agreement providing it is not tainted or it is not unfair. The needs of the parties by far will override any question of arrangements made between the parties, but for completeness, consequential changes that happen in marriage can render those agreements perfectly unworkable. So there are some serious practical considerations that need to be put into place when considering how to put together a prenuptial contract. I wonder if we can move forward, please, Joe. One of the most useful provisions is to have a consideration of what is going to be happening in the interim of any proceedings and weave into the contract something, for example, looking at maintenance pending suit, preempting what could be disagreement between the parties. This allows the parties time to validate the contract and see how far that they can reach into it to find that it meets their needs. There needs to be a good understanding that the agreement does meet the needs of the parties when they enter into the agreement, and that agreement will need review over a substantial period of time through a rigorous testing and a meaningful review. It's also very helpful to put inheritance provisions within the contract so that can be incorporated into a holistic option. And more importantly, again, to look at contingency elements that can be brought into the agreement, and particularly exit clauses for any party, whether it is when it's relevant for them. The next case that I'm going to move to is that of Preston Petrodollar Resources. I don't think this has ever been attempted in 5 minutes, but I'll have my best effort here. I will start with a presupposed and presumed knowledge that everybody accepts and understands the doctrine of the corporate veil and understands that companies have a separate legal identity to anything other than themselves and is the same as people. If we move forward, this was a question of asking whether there should be a piercing of the corporate veil. The wife was making application under 23 and 24 of the Act, and her question was seeking whether or not property that was rested within companies that were owned and controlled by the husband were going to be part of a foreseeable settlement for her. The appeal concerned a number of companies known as the Petrodollar Group. The more commercially minded practitioners amongst us are going to be extremely familiar with the principle of the case, because it effectively looked again at every aspect of a company's independent identity. There was an uncontroversial earlier finding. The matrimonial home was held within the company. As part of that, it was beneficially held for the husband. And at the time of the appeal, the wife was more concerned with companies in a number of subsidiary companies that belonged to into the control of the husband. The journey of the observation that the court made touched deeply into the independence of the company, and again didn't highlight any greater allowance within family jurisdictions. The ownership of the companies was very difficult to establish, and it was also so puzzling that the judges found it very difficult to make findings. There were huge complexities because of the husband's lifestyle, and his expenditure didn't in any way reflect what was happening in the circumstances. But the drive of the inquisition into what was happening was really brought about by, again, the power of Section 25. If we can move on to the next slide, please, Joe. It was held that the husband was indeed the beneficial owner of these relevant assets, and that was as part of a resulting trust, which did indeed engage Section 24, but the discretion was what underpinned the consideration, because in this instance, despite behaving fairly despicably throughout the proceedings, there was no deliberate effort on the part of the husband to evade his obligations, to provide the position where the wife was being prevented from attaining her interest in that asset. What had happened was he had put the companies together in the structure that he had, most relevantly on the basis of his tax position and the control position. Now, the Supreme Court in this instance did permit some of the transmissions of ownership, but it was not on the basis of lifting the company veil. It was deeply bedded into the individual facts, where in this instance, this husband had controlled the properties in such a way that there was very little option other than to assume that there was a trust resulting that allowed him to pass on. Because this is such a complex case, the message that I want to be taken from it, and those familiar with this area are going to be very familiar with relevant considerations of restricting or diverting resources or transferring shares at interlocutory stages. It is a question where the transfer of ownership needs to be tested very, very carefully at every single stage. If you know your Section 25, it does equip you with the power tool, because it allows the company to look at all the assets and resources available to the parties and make some levels of conclusion. The difference being, of course, if somebody puts a corporate impediment in the way, that will open potentially a different area for analysis here. Now, because I thought this was a top 10, you've got a bonus case here. We're going to go very quickly to the case of Hodkinson and Hodkinson. It's probably a bit of a relief after the rather tough chew-through press, but effectively this is where you've got situations of contempt and non-compliance. I wonder if we can skip to the next slide, please, Joe. There's an unqualified obligation that rests between parties when they're approaching the court at all to be in compliance with obligations before them. In this instance, there was a situation where this is a custody hearing that's grown into something quite useful in financial hearings. The case grew out of a custody hearing when a wife was restrained from taking children to Australia. She did that The husband wanted her to bring the children back. When engaging in the litigation about that, she had still not brought the child back into the jurisdiction, and the husband took issue with her actions and said that the failure for her to comply with the first order should be a restraint to her making her application under the second. And it's right that there remains an unqualified obligation to cooperate with an order unless or until any order is discharged. So there's a question of purging the contempt before things moved on. It's a particularly unusual case, and the remedy to financial proceedings is it's useful to prevent a party from taking a future court action before there's been compliance with the first. So where a party is willfully and failing to pay, maybe maintenance, maybe a lump sum, the offending party may not be allowed to reapproach the court, for instance, to vary on appeal or make variation for the maintenance orders that are made. And this is really the gift of Hodkinson. I wonder if we can move forward, please. Perhaps again. The offending party has to effectively, the allegation is that there will be 6 key questions. The first question, of course, is the offending party in contempt? That's extremely important. Does that contempt, and this is a very key factor, lead to an impediment of the course of justice? Is there any other effective means of securing compliance with the order? And should the order should the court order exercise its discretion to impose those conditions, having regard to those questions? Is the contempt willful and continuing? And if so, what conditions would be appropriate? It's extremely important that those questions are borne in mind on the journey to the application, because all of the areas will be tested. And of course, if there is any other jurisdiction or any other area of law that could have been tested before, it should have been so. If we move to the next slide, please. The applications are made under the family procedure rules. It's a simple procedure under Section 18, and it will be for determination under the 6 areas that I spoke about. But you have to be very, very careful, because there can be good argument to say that this determination is not compatible with Section 6.1. So, as a recent example, there was an instance where there had been a non-payment of a maintenance order, and it was found impossible to enforce this order against the husband because the wife had no access to any funding for her case. The husband was trying to appeal. In this instance, whereas the non-payment of maintenance was not appropriate to be covered by the Hodkinson's order, the little diamond was that the provision of the order to assist with the wife's legal costs in relation to responding to the appeal was considered sufficient to allow that to be paid before the husband was allowed to proceed with his appeal. So again, another lovely little case when all other efforts of enforcement have fallen flat, perhaps assets are outside of the jurisdiction. But again, hopefully to add to the battery of little cases that work within the financial division. But they remind us all of the work of Section 25 throughout every single one of these matters.
Melissa and Vicky, can I thank you very much for giving your time to this seminar today. I can see that we've had a few comments from those listening about the slides and the detailed handout. I know that Vicky's answered, but again, I'll say it for everyone else. Those can be found on the website probably from tomorrow. There's going to be a recording, a link on our website and a recording of this seminar. I think it takes you to a YouTube page where you can watch this again, should you wish, at any time at your convenience. The detailed handout will be there to download, as well as the slides separately in PowerPoint. So everything should be there for you to access. But any problems, do email our clerk, Scarlett Watkins. Her email address is there. Also available should you wish to instruct counsel or for any further questions. I can see we've had one question. Perhaps if I read this out loud and we can see if either Melissa or Vicky can help. Regarding disclosures, if a person obtains the information innocently and then sends them to the other side, could it be argued that any further application for disclosure would be a fishing expedition and render futile? Surely a court would come to the aid of to prevent false or concealed information.
I should probably go for that, Joe, because that comes within Immerman. What I think, thank you to Raymond for that question. What we need to remember here, first of all, is that with disclosure in financial remedy proceedings, it goes through a very set process. So we have exchange of Forms E, we have questionnaires. If it's deemed that the replies to questionnaires are insufficient, there's an opportunity to raise a schedule of deficiencies and so on and so forth. So first of all, we've got this very clear pattern for disclosure and how it evolves throughout the course of proceedings. I think what Raymond's question is getting at is that sort of scenario, say, where someone leaves their bank statement on a coffee table or something along those lines. In the light of Immerman, my advice would be going back to what I said about returning things unread and not relying on them, because sometimes it can be a bit of a grey area where it was left lying around and so forth. So one mustn't get sucked into the previous Hildebrand way of thinking, which was obtaining innocently, sent to the other side, rely on it. So that's the distinction. Hildebrand, it was fine to do so. Immerman, send it back. Don't rely on it. There's a wider question here about the court not sanctioning false or concealed information, and that goes back to my point about there being other remedies in order to obtain disclosure, going back to the seize and search remedies and so forth. I think may I take this one, Joe, because this goes on the Immerman point again from Aziz saying, is there any liability for solicitors where an Immerman document has been obtained by a client? Of course, this depends on the particular circumstances of the case. But what I'd suggest is that if you follow the process properly, and that's why I very much advocate erring on the side of caution, by indeed returning matters and following the precepts of Immerman, then you're very much justified in the stance you've taken. I would suggest you'd run into problems if you were to know, for example, that your client had broken into their husband's safe or their wife's computer or so on, and you knew that and then sought to rely on the documentation improperly. So if you steered clear of that and falling into the old Hildebrand ethos, you should be fine as long as you are aware of the obligations under Immerman. I hope that answers that question. Thank you.
Well, thank you, everybody. I don't think we have any further takers for any questions. Again, you can find this recording together with the detailed handout and everything on our website, as well as a list of our further seminars, should you wish to take part in any of those. But thank you very much for joining us today. Vicky and Melissa, thank you for your time. Unless there's anything else, I propose to close there.
Bye, everyone. Thanks very much indeed for joining us.
Thank you. Good afternoon, everybody.
Bye.